Ms.
Thank you,
Townsend. Thank you.
Mr. Collier, I'm going to continue now with the theme of last resort. I want to just go through your conclusions, and in particular, which relate to what you've said in your first report and how that's changed in relation to particular incidents in your third report. So in your first report, at paragraphs 82 to 83, as I've said earlier, this is page 16 if you want to turn to it. I'm sorry, in fact, this is your third report, rather. In your third report, INQ 000177, page 16, you said, based on the additional evidence that have now been provided, I've identified a number of incidents where the interaction between the DCM and detainee was not sufficient and does not evidence that all reasonable efforts had been explored in order to gain compliance. This is essential when justifying force was used as a last resort and that other methods had been tried without success. And you then list 5 incidents, as I said earlier, 86, 88, 108, 129 and 153. And all but the first, 86, are incidents which you changed your mind about having seen the footage. Is that correct?
Yes.
And they all relate to whether use of force was a last resort.
Yes.
When you reviewed the incidents in your first report, you divided them up into of concern, and that relates to your first part of your report, and then not of concern, which is your second part of your report. Is that right?
It was, the evidence I was given was broken down into 2 areas, and the first lot were the major concern ones, and then the ones of lesser concern, yes.
And for the former, which were of concern, there are about 22 incidents.
Yeah, I can't remember exactly, but yeah, I'll take it that.
And mostly, if not always, it's correct that you were able to review video footage for those incidents.
Yes.
And generally, for the latter, which you had marked of not concern, there was little, if no, evidence of
Some of
video
them
footage.
had no evidence whatsoever of video footage, yes.
So in general terms, most of the footage you reviewed caused you concern.
Yes.
After reviewing the additional footage for the 18 incidents for the third report, as I said, you changed your mind in relation to 4 of them, and one of the incidents, which was 86, involving TD2159, your concern was strengthened about whether force was used as a last resort.
Yes.
What does this tell us about the importance of video footage?
I think it tells us 2 things, that video footage is essential to get a true reflection of the incident, but also about the use of force report writing needs to be to a better standard and more descriptive of the actual events.
And why does the report writing need to be more descriptive? Do you mean because there may not be video footage, therefore?
If that becomes the norm, then if there isn't footage available for whatever reason, at least then we're more reassured, or we've got greater reassurance that actually what's being written down is a true account and reflection of the incident itself.
And did you find an issue with the quality of report writing?
Yeah, huge issue, yes.
That's something that we'll come on to later in terms of review process. What also does it tell us about the adequacy of the review process in itself? The fact that when you had seen all of this footage, that your mind had been changed as to almost a quarter of incidents.
I think as well, and if I think back to the incidents themselves, although yes, I looked at it from, dare I say it, an expert eye, even someone with lesser experience than myself would have come to the same conclusion. I'm confident of that. And it's areas that we've covered already, that there wasn't sufficient engagement, they hadn't attempted all reasonable options, and that force was used prematurely.
When you say someone not as an expert, do you mean a use of force instructor?
I think even a manager of some grade should have the ability to look at that footage and see that there was something wrong, as in they hadn't fully exhausted all reasonable options, yes.
And what, if anything, does this tell us about the adequacy of the review process at Brook House?
From the evidence I've been given and from what I've seen, it was non-existent, as in the fact there wasn't a multi-agency, multidisciplinary committee in meeting. I've had no evidence of no minutes, no terms of reference for such a committee. So I can only draw the conclusion that it didn't exist.
And can any conclusions be drawn about the 70 or so remaining use of force incidents which occurred during the relevant period which you were not asked to review?
Well, it would definitely raise concerns about what them incidents entailed, what the actions were, and were they even justified? Yes.
I want to turn now to two of the recommendations which are relevant to use of force being a last resort. Your recommendation 2 in your first report, page 148, you've suggested this, that there should be a consideration of a bespoke package for staff working in IRCs to cover behaviour management and be therapeutic based, focusing on preventative strategies as opposed to reactive strategies when a situation has escalated. Training and managing difficult conversations is essential for all roles within a detention centre and should be included. However, a greater asset will be for better staff training that utilises preventative strategies by recognising and managing potential risks, brackets, understanding of preventative strategies, as opposed to reactive strategies when a situation has escalated. In plain English, does that mean that basically there should be more negotiation before a use of force incident takes place?
There should, and what there should be is more standardisation across that. So it shouldn't be left to individuals to interpret in their own way how negotiation, how persuasion should be carried out. There should be a set programme that, because at least then everybody's working to the same process and everyone understands what colleagues are attempting to do, what their outcomes they're desiring are, and that everyone, as I say, it's a standardisation so that we know that that's in place and we have the reassurance that that is what staff are using before having to resort to the last resort of using force.
And should there be a specific module on, for example, managing difficult conversations or understanding preventative strategies?
I think so. I think that's part of the overall curriculum, and I think that's, and like I said earlier, that should precede any use of force training in the initial training of custody officers.
So that should be in the ITC, the initial training course?
Yes.
We've seen from the ITC scheduled learning from Serco, it's an exhibit from Steve Hewer, which is SER 000253, that isn't, or nothing similar is on that training course. So I assume that you would advocate for that now.
Yes, definitely.
The second recommendation, which is your recommendation 4, is that the first report, pages 149 to 150, paragraphs 645 to 646, and this is management of removal. You've suggested that Home Office staff should inform detained persons of removal orders, DCMs to support and familiarise with particular case, standing operating procedure to be produced to reflect this change. So essentially what you're suggesting there is that a member of staff should be with a planned removal team, a planned use of force team, to explain what's happening and why they're removed. Is that right?
Before it even gets to that stage, I think it should be somebody from the Home Office that explains to the detained person exactly what's happening and the reasons for it. I feel that sometimes the DCM grade would be lacking the knowledge and the kind of case history to engage constructively with the person at the time, and I think the process should be slightly different. That's my view. Is it somebody from the Home Office also has a little bit more credibility when explaining to someone about removal orders than somebody that's seen as a custodial officer in an establishment.
We heard from in our live evidence of Vanessa Smith, who is a Home Office pre-departure scheme engagement officer. It's at INQ 000173, page 57, internal page 228, that a Home Office representative is not usually present when a detained person is being moved in order to be removed from the country. But from what your evidence is today, you're speaking about something before that.
Yes.
Would it also be beneficial when somebody is being told that they need to leave?
Yes, definitely. It's all part of that process, and again, repeating what I said earlier, it gives the case background which I think, and also a lot of the times on the footage, you could actually hear people saying things like, I've got an appeal going in, or I've got this is happening, and they'd be better informed to explain how that process is working, whereas I dare say that the DCM would have very little, if any, knowledge of that.
I said there were 2 recommendations applicable. In fact, there are 3. Recommendation 10 in your first report, pages 154 to 155, paragraphs 647, 649, you've suggested that Brook House should have trained negotiators to assist with serious incidents. And you gave the example of when D275 was on the netting. Why would a trained negotiator be particularly helpful, do you think?
Well, they'd have additional skills to a normal member of staff, and they would go through a bespoke course that would teach them negotiation tactics. So what would happen then is whoever's in charge of the establishment at the time would set out a strategy for negotiation. The incidents I saw on the netting, there were no attempts at engagement. There was no strategy in place. It looked as though nobody took overall control. And I think having trained negotiators could help with serious incidents, but them skills are transferable then for other incidents whereby they have to inform somebody that they have to move. So they'd have a really multi-purpose function within the establishment.
And is this something that's already takes place in prisons, or
Yes.
is this something?
Yeah, every prison will have a number of trained negotiators.
And so your suggestion is that it should also be in immigration removal centres?
I think in any custodial environment where there's movements and times where incidents take place, that somebody's there who can negotiate, as I say, to a strategy that's not only been devised, but it's been devised by psychologists, and it's got background to support its content.
We know from Mr. Hewer's witness statement, but I'm sure he can give evidence about this when he gives evidence later this week, that there is no mention of hiring or using trained negotiators, but this is something, again, that you would recommend for Brook House particularly.
Well, from my knowledge, Mr. Hewer was a previous governor grade in a prison, so he would know the benefits that the negotiators bring.
I want to move now on to the 5th topic, which is a rather large one, which is use of force against unwell detained persons who offers no threats. I'm going to take you to 3 incidents, and the first 2 relate to detained persons who are physically unwell, although in relation to the first person, he's mentally unwell as well because he's refusing food and fluids. And then thirdly, an incident where somebody is mentally unwell. In your first report and your conclusions at paragraph 665, you have said that you've placed incidents 86 and 134, the 2 incidents we're going to look at in a moment, together, as there is a theme about 2 which is concerning. On both occasions, the detainee who had been authorised to be moved was not in good health, and certainly in 134 offered no physical threat to staff. The reports from 86 indicate a man who is very weak from being on food refusal for some time. My conclusion is that there was no lawful reason to enter the room with a team in full PPE and use a shield against him, even if it was, as described, placed on him. The footage from 134 also shows little threat to staff, with a man who, despite the doctor confirming he was fit for removal, demonstrated only reluctance to move. Incidents of this nature must be managed as a medical removal rather than a disciplinary move. It was unnecessary to have staff in PPE, and even so, more so, to use a shield. Mr. Collier, what's a medical removal?
That is somebody who's removed from normal location to somewhere where they can get a greater level of medical attention. So to another part of the prison, the establishment, whereby they would get better attention and more sort of solitude rather than being in the general population.
And how would that be different to a disciplinary move?
A disciplinary move is for somebody who's offering threats of violence, someone who offers a risk to the good order of the establishment. So that is massively different to somebody who's being moved because they're unwell. So
it goes to the reason that somebody is being use force is being used.
Yes.
Whether it's a medical removal or a disciplinary move.
Yeah, I think it's, in my opinion, it's far harder to justify using force for someone who's being moved for a medical reason than it would be for somebody who's offering a threat to the establishment or threats to staff.
And in these cases, the person, well, in the first case, a person was being moved to another room, purportedly because there were concerns over his condition. So you're saying that a medical removal would have been more appropriate?
Yes.
So if we can look at that first example then, it's of D159, example 86/17. You've summarised it in your first report at paragraph 125, and you state this. D2159 had been refusing food and fluids, and healthcare raised serious concerns over his condition. His room was unhygienic, with urine on the floor, and D2159 was not engaging with staff. He was to be moved so that a constant supervision could take place. Staff and PPE were instructed to restrain D159 before handcuffs were applied. He was relocated with bouts of difficulty, mainly due to weakness from the lack of food and fluids. Zainab, please could we bring up CJS 005529, and it's page 27. This is a use of force form. I want to highlight a few sections from the use of force form. This is the briefing script from, again, DCM Dix. And in the middle of the page, we see "and is" starting, is being moved to Eden Wing due to healthcare concerns over his food and fluid refusal. Healthcare hold serious concerns over his current medical condition. The detained person's hygiene has deteriorated, and he is now urinating on the floor. Therefore, for his own welfare and health and safety of others, the detainee is to be moved to a unit that provides increased supervision. If we can go to the same document, page 17, please. And this is DC O'Neill Tim's a counterpart of the incident. Let's double check that's the right page. I don't think it's the right page, but I'll read it out. It's DC O'Neill Tim's account of the incident. He says, we made our way to D-Wing room 201, where the detained person was. DCM Dix opened the door to his room and we entered. The detained person was laying on his back on his bed with his head at the end of the bed, which was closest to the door. I led the way with the shield, and DCO Rowley and DCO Cunningham followed behind, with DCM Dix at the back. I held the shield over the detained person, with it resting on his chest area to protect the team from any aggressive response that the detained person may decide to do. If we turn to pages 25 to 26, please, which is the healthcare form. Just scroll up, please, to the top. It's the report of injury to detainee form. And we can see at 2B, no force was used as the detained person was compliant. Next page 26, please. E-Wing, the detainee refused healthcare input, no injuries noted to the detainee. Please, Zainab, can we now play the footage which relates to this incident? It will have to be enclosed, please. It's S1970002. CJS 00. Ms Collier, in your first report, you hadn't seen any of that footage, had you?
No.
In fact, you hadn't seen any footage at all.
That incident, no.
For that incident?
Yeah.
Yes. You've said in your first report, paragraph 127, that you were concerned that despite the obvious condition of the detained person, that the DCM decided to put staff in full intervention PPE, including a shield, and that what should have been worn was safety overalls and face masks. You also say at paragraph 128 that there was no evidence from reports of healthcare engaging with a detained person or what the care plan was. Were you referring then to a plan beforehand or during the incident? What would you have expected?
I would have expected healthcare to have been in attendance with the DCM in the first instance. As you saw from the footage, the DCM looks through the observation panel and then just opens the door and sends staff in, which, again, in my view, was unnecessary. He could have gone in with a member of healthcare to check on the condition of the detained person, and I didn't feel there was any need for the shield to be used or for the staff to be in protective equipment of that nature.
Indeed, you say at paragraph 129 that even without the footage, you don't believe force used with a shield was ever necessary.
No.
And what about handcuffs? Were they appropriate?
No.
We've seen that the healthcare form, the injury of detainee form F213, we saw it on screen a few moments ago, states that he refused healthcare. Did you see any evidence that he refused healthcare?
I think the only time that was right at the very end. I think then healthcare went in and then left shortly afterwards without any observations taking place.
And was there a refusal or was there simply no response?
Didn't hear him say refuse it. It just, I think it was probably more unresponsive to the questioning, yes.
We know from his patient record, which I won't bring up, but it's CGS 007001, page 1, on the 5th of April, that there is a comment there that says restraints may be used. And then under the 5th of April at 1747, it says history moved from E-wing to E-wing by officers. No force required as detainee fairly weak. And this is written by a nurse and clinical lead at Brook House, Chrissy Williams. Chrissy Williams gave live evidence to the inquiry, and it can be found at INQ 000168, page 27. She gave evidence that despite writing that restraints may be used, she didn't expect a planned use of force to occur and just expected, quote, asking him to come, so holding his hand rather than anything else, which if he refused could be counted as a first restraint. She agreed that it wasn't healthcare's role to sanction force that was eventually used, and she also agreed that it was wrong that force was used to get him to E-wing, and that she should have intervened to raise contraindications, essentially reasons why force shouldn't be happening. Would you agree with that?
I'd agree with all of that, and the use of force is any physical interaction, but sometimes you use it for a medical reason. So if somebody's struggling to walk and you want to assist them, although there's physical contact, that's not a use of force as in what is deemed use of force in the context we're talking about it now. So my assumption is that that's what the nurse meant, is that he would be assisted rather. I think the terminology is probably not helpful. If it was assisted the person to move, that would be within their remit to say to staff, yes, you can assist them down, but they can't authorise using force, no.
And I assume from the video you think that wasn't just assisting somebody?
No, the DCM actually has told the staff what techniques to use. At one point he says, apply figure fours. Then when the handcuffs were put on, he said apply wrist locks or final locks. So he's telling the staff to use a physical technique, yes.
You say in your first report, paragraph 13, that even without the footage, he presented very little, if any, threat to staff. And you say, I accept the unhygienic state of the room, but using staff in full PPE, followed by the shield being placed upon him, are completely disproportionate and unnecessary.
Yes.
A full assessment before the intervention would have identified the level of risk, and the response should have been proportionate to that risk. So would it have been helpful for an assessment to have been made before use of force was used?
An assessment should have been made from the very outset, from when they entered the room.
In your third report, INQ 000177, pages 9 to 10, in fact, page 10, you describe the use of the shield, and we saw there in the video that it was placed on D2159 for a short period after he doesn't respond to DCM Dix. What's your view on the way that the shield was used?
Not the way it was used, why it was used. I see no reason why the shield was necessary. The shield is used to protect staff from levels of violence offered against them, and at that stage the detained person was unresponsive, so there was no threat, there was no risk, and I think using the shield there was, as I said at the time, disproportionate and unnecessary.
And what about the use of handcuffs? Was that proportionate and necessary?
In my view, no, because I think more effort should have been made to assist move him rather than apply what is an extra layer of control and restraint.
You say, finally, in your third report at paragraph 13, that my initial opinion of the incident remains and is supported from the footage, which gives clear evidence of the risk and threat offered at the time. Do you have anything else you'd like to add about that incident?
Again, like previously, the efforts at engagement were very short. There was a short period from a few questions to ordering staff to restrain the detained person. So, again, it's that theme all the way along that there isn't sufficient engagement and attempts at persuasion and negotiation, and even more so this time because of the unresponsive nature that the detainee presented. That then they should have looked at other methods and tried to sit down and explain more what was happening.
I want to move now to a second example, an example that's come up, or a detained person and a use of force example that has come up throughout the inquiry, and that's of concerning D1914 and incident 134/17. This was an incident on the 27th of May 2017 where force was used on D1914 who had a heart condition, and it was used in order to move him to Ewing before a flight the following morning. First, I want to ask you about some dialogue which the inquiry has heard about the incident before it happened. You've commented about this in your report as well. It's a discussion between Callum Tully, Jan Pascali and Dave Webb about the use of the shield. It's in TRN 000087, pages 16 to 17, lines 596 to 600. An unknown officer says, "If he dies, he dies." Then Dave Webb says, "At the end of the day," inaudible, rolling his fucking head, inaudible with the shield, "so I wouldn't worry about it." In another transcript about the same incident, TRN 00000013, pages 1 to 2, internal page 1, Dave Webb says, "Hit with the edge anywhere between the knee and the throat, and you just keep fucking going. Hit him with a big gun." When asked if you meant the shield, hit him with a big gun. He then said, "Yes, you don't stop until he's got nowhere to go." In live evidence, which is at INQ 000159, page 36, internal page 141, David Webb agreed that this was not the correct approach in terms of the use of the shield. Can you describe what was wrong about how he was directing Callum Tully to use that shield?
What he was trying to sort of explain to the staff was to use what we call the bladed edge, which is the edge of the shield. So if the shield was lifted up, it would be the edge at the bottom of the shield. What he's trying to explain is that they would use that deliberately in a deliberate action to target the area that he specified between the knees and the throat, and that's not the case. the shield is held in that position, what we call a 45-degree angle. That's for when you're dealing with someone, as I said earlier, someone who may be armed, to create distance. However, when contact's made, it's made with the flat of the shield, so the shield is then lifted and brought up to a straight up angle and then placed against the central body mass, and then it would target the potential weapon arm or the area of threat.
And what is wrong with the angle that he was suggesting when if it's used to make contact with a person?
High degree of risk of injury, because you're using as I say, it's termed a bladed edge, but it's not actually bladed, but it could be quite a sharp edge. So that driving into someone could cause considerable injuries. Certainly if he's talking about going anywhere towards the chest torso, it runs the risk of deflecting into the throat or face area as well. So the likelihood of injury is increased from that as well.
Well, in fact, he said the knee and the throat.
Yeah.
What would happen if that edge was caught near the throat?
Could range from anything to the most extreme.
Extremist, you mean a fatality?
Could potentially, yes, yeah. If a direct blow to the throat area, yes.
And how concerning is it to you that it is a use of force instructor, Dave Webb, who provides this, as you call, incorrect advice concerning the shield?
That's hugely concerning. It's part of training. It's always been part of the training. It's never been any amendments to the use of the shield. It's remained that way for ever since I've been involved, and it's concerning not only because that's what he's explaining, but that's then what he's teaching staff as well. So that then becomes again the normal practice in that establishment, which again leads to a high risk of injury at any time.
Would you agree also that it sets the tone for use of force equipment being offensive tools rather than defensive?
Yeah, the shield, as I explained, is a defensive implement, protects staff from the risk of serious injury until such time as they can gain control of the threat in front of them.
I want to move on now to the incident itself. You summarise this in your first report, paragraphs 97 to 98, as follows. You say that D1914 was due to be transferred for a flight to Romania the next day and was required to be relocated into Eden Wing. D1914 refused to comply, and a letter signed by a medical professional confirmed he was fit to fly and fit for detention. He will need a medical escort due to the nature of his medical condition. I am happy for reasonable force to be used to facilitate the removal. Paragraph 98. Staff in full PPE carried out the removal. The footage shows DCM Dix open the door and the staff enter straight away. D1914 refused to move and is forced to be placed in handcuffs and then moved to the CSU. I'm not going to play the footage because we've seen it lots before, but if anyone wants to recap, it's at INQ 000098, page 17, day 8. Essentially what we see there, and you've reviewed this footage as well, is officers all go in helmets, full PPE and shields. You see the detained person lying on the bed in boxer shorts. He's saying, please, please. He's given one chance by DCM Steve Dix. He says, why do you do this? I'm sick. I've had 3 heart attacks. Please, I die, I die. I'm good, finish, stop. And he's breathing heavily. He says it's not possible to walk. He sits on the bed and he says, I'm not feeling good. We know this also from D1914's account to this inquiry as to how he felt when force was being used on him. His witness statements at DL 0000229, pages 42 to 43. That's paragraphs 150 to 155. In his witness statement, he describes howling in pain, struggling to breathe, and telling officers multiple times that he has heart problems. You've reviewed this incident again in your third report, and you see another different type of footage there, CCTV footage. And you say, after seeing CCTV of the incidents, it's paragraph 4, page 4, after seeing CCTV of incident, you state that the detained person is only dressed in a pair of shorts and that you would have expected him to be allowed to put on a T-shirt. CCTV enhances my opinion that handcuffs were unnecessary and staff should have at least removed helmets prior to moving through the centre. So is this another example of where PPE should not have been used?
Yes, I don't think it should have been used from any time during that incident. It's clear there was no physical threat at the time. The staff, it was really evidence later on that he offered no threat towards the staff as far as violence towards the staff. It was only about him feeling unwell at that time. So again, it's one of those that if a proper assessment had taken place beforehand, there would have been an assessment made. A decision then should have been that staff just go in and try and explain what's happening and then assist move again. So there's a lot of similarities between the two, which is why I think on my report I bracketed them together, because I think they're very, very similar in their nature.
And again, you've said that handcuffs were unnecessary, like the other incident we've just spoken about as well. Again, is that because of the level of threat that the detained person posed?
Yeah, and I think the staff just needed to help him along rather than, say, use the cuffs as an extra measure of control.
Earlier on, you said that that these incidents should be treated as a medical removal.
Yeah.
What difference would it have made to this incident with D1914 if it had been considered to be a medical removal?
I would have expected healthcare to have had more part of the engagement, to maybe go in straight away with the DCM, to carry out the observations, do all the necessary tests that they need to take at that stage before they decided to move him.
Well, there was some input from healthcare. We know because of the fit to have force used on the same person, a fit to fly letter. We heard from the doctor that wrote this letter, Dr. Uzarali, and he gave live evidence to this inquiry a few weeks ago. He says at INQ 000169, page 34, internal page 134, that he provided this letter to say that he was fit for force to be used and fit to fly. And he said that this was despite the role of healthcare only being to provide any contraindications, so any medical reason for a person not to have force used upon them. He said that he did not feel that he'd sanctioned it, and the wording was, quote, really unfortunate. Do you have any comment to make about the use of a fit to have force being used on you as a letter?
All I could say is I'm not sure that's quite within the remit of a healthcare professional to say force can be used. I think what it can say is that if force is used, that they have medical attention and attendance all the way through. But I don't think they've got the right, and I stand to be corrected on that one, but to my knowledge, their role is to care for the care and welfare of the person rather than authorised force.
And in your prison experience, have you seen any similar kind of letter which sanctions force to be used on a prisoner?
No, it's normally just fit for transport, fit for travel.
In your first report, paragraph 124, your conclusion is that D1914 did not offer a level of threat to staff that justified their actions. The force used was not necessary, and more time should have been taken to try and persuade compliance with the instruction to move. I'm even more concerned at the lack of consideration for the condition of D1914, who appeared unwell and unlikely to present a safety risk towards staff. Do you have any final comment to make in relation to that incident?
I think you put up earlier today the manual section that gave the criteria for when staff should use PPE, and I think when you judge it against this situation, I don't think there's none of it actually justifies it at that time.
I want to move on now to a third example under this topic, which is the incident with D1527 on the 4th of May. By way of background, D1527 had been diagnosed with by the mental health team 2 days prior to the incident. He was on a period of food and fluid refusal. He jumped on D-wing netting and had threatened to throw himself off. Officers and detained person watched until the detained persons were eventually put in their cells. Several officers are filmed mocking D1527. D1527 then goes to a friend's cell to calm down. DCM Dixon decides to put D1527 on Rule 40, and therefore a plan is made to remove him to E-wing. DCM Dix and DCO Yates enter the cell to inform D1527 and warn him force will be used if he does not go compliantly. Officers then use force, including a pain compliance technique, which is the thumb flexion or lock. And DCM Dix does not mention this in his report, and DCO Yates does not provide an explanation. DCM Dix does not turn his body-worn camera on, which you find in your first report to be unacceptable. So your first report, paragraph 270. In your third report, you considered body-worn camera footage, which hadn't been available in relation to the use of force incident. And I should say that this is separate after the incident where he came off the netting, where we understand he came off of his own accord.
Yes.
There were two pieces of body-worn cam footage. There was, this is the reference number 114.17 BDWCA, and use of force UOF 114.17 BWCB. You've only mentioned A in your report. Is it right that you've also seen B footage?
Yes, I saw both pieces of footage, yes.
These questions are from D1527's representatives. So there is body-worn footage of when D1527 has arrived in E-Wing and a full search is taking place. That's body-worn footage B.
Yep.
We see DCO Yates telling DCM Dix to hold the body-worn camera outside, quotes, for the audio, whilst the search takes place. However, by taking the camera outside, the discussions between DCM Dix and D1527 is inaudible. It is not until the officer goes back in to question about sterile clothing that the following audio is picked up. And the audio is follows. When we leave the room, someone's going to watch you, okay? If we leave this room and you start self-harming like you've done before, and obviously like you do, then obviously that, your behaviour dictates what happens in your future, okay? No one wants that, okay? If you stay calm, inaudible, but I told you, the way you've gone about things, jumping on the nettings, is not the right way. You should have spoken to a manager, but your problem is that you go from okay to lose this plot in 2 or 3 seconds, and that's what's landed you in trouble. And then DCM Dix confiscates D1527's trousers. In your third report, paragraphs 18 to 19, you've mentioned this footage. Does any of that, in terms of body-worn camera footage B, change your opinion to do with the use of force?
The only point I'd make is that normal practice is for the camera to be diverted, not removed. So whether it's a handheld device or whether it's a body cam, it's normal practice to focus it away from the person who's being searched, but to stay within the area, as you say, to pick up the audio and the dialogue that's taking place.
And so that's what sort of happened in this instance, rather than removing the camera out of the room.
Yes.
I want to ask you about a pain-inducing technique that was used on D1527 during this incident. During his transfer to segregation, D1527 was subjected to this pain-inducing technique from DCO Yates. This occurs when officers are trying to move D1527 out of D-Wing through a doorway and into the corridor. The incident's not covered by CCTV, and Yates applies this pain technique in the corner of D-Wing, again, that's not covered by it. So the only evidence we have of the pain-inducing technique is from DCO Yates, which he says in his use of force report, which is at CGS 005530, page 18. He says, "We left the room and began walking to the back exit on level 1 of Dove Wing. Just before leaving the wing, Mr. D1527 began struggling and pushed his way to the wall. After a struggle, I applied a thumb flexion lock back onto D1527. We then moved forward and made our way to Eden Wing." He doesn't provide any further information or justification for that. You address the use of the thumb flexion lock briefly in your second report at paragraph 17.4, page 43, and you state, "My only concern is that a pit technique was used when handcuffed and the lack of information provided by DCM Yates. This would have been at the point where I would have to consider the proportionality and necessity of force for that part only. We've been through already, and you've told us already about the rules regarding pain-inducing techniques, that they may only be justifiable if it is the only viable and practical way of dealing with a violent incident which poses an immediate threat of serious physical harm to prisoner, officers or others, and that officers must be able to explain the reasons for using a pain-inducing technique as part of their decision-making process, and be able to set their approach on the subsequent use of force report. And in addition, that the prisoner must be given a clear, simple verbal instruction and should only be applied for approximately 5 seconds. Your conclusion at page 84 of your third report is that NB, it is accepted that it is in certain situations these guidelines will not be possible due to the immediate risk to officers, the prisoner or others. In those situations, officer will give clear instructions wherever possible during the application of pain-inducing techniques. Based on the description of DCO Yates and evidence from the footage where the staff struggle once they reach the door, the use of a pit would be justified. However, at the time of this incident, DCO Yates would have been aware of the following. He would have been aware that D1527 was severely mentally unwell, that he was securely held in handcuffs, and that there were at least 4 officers present. Do you agree that DCO Yates' description in his report of the pit does not, on reflection, meet the requirements of the manual in terms of justifying why it was necessary?
No, when you base it on the information that's available, the risk at the time as well. When I talk about times when you wouldn't give an instruction, that could be something like if someone had, for instance, an edged weapon in their hand, and you had control of it and you used a pain-inducing technique to break the grip on the weapon. There you wouldn't expect someone to go through that structured approach. It would be more a case of just do it as a, just preservation of life situation. So in that situation that's been described, having seen the extra footage, having read more evidence that's come through, there is very little to state or to justify why that decision was made, but also why why the supervising officer didn't record it in their report, why it wasn't reported there, and why it wasn't addressed by the supervising officer about why staff felt it necessary to use that technique.
So was the pit justified, do you think, in those circumstances?
There's no evidence to suggest it was, no. So there was nothing there to say that there was such risk or such potential risk to staff or risk of harm that it was justified, no.
And do you also agree that the use of force manual makes clear that the effect of mental health is relevant to whether your force should be used, in particular relevant for Article 3 purposes?
Yes.
No need to bring it up, but the manual NOM 00001, page 30, states if an officer uses force and the use of force cannot be justified, depending on the severity of the force used, this may amount to a breach of Article 3. You notice a point of concern at page 43 and paragraph 17.4 of your second report, that the pit was used when D1527 was in handcuffs. What risks are there? I think we probably covered this already with other pits that have been used in handcuffs, but could you just remind us of the risks that there are to using a pit technique, the wrist flexion, when a person is in handcuffs?
Thinking sort of on the spot here, an example would be if, for instance, the person that's had supporting head is being bitten. So if someone was biting them, that they could use a pit in that situation to prevent the risk of harm to the person there. So that's an example where you would say a pit whilst handcuffs are applied could be justified. Obviously, in this situation, there's no such reference to anything along them lines. And as you say, very similar to the earlier situation, there is no evidence given that would say well, actually that was justified in them circumstances.
On a related theme, I want to ask you now about the model of use of force against mentally ill detained persons. You've accepted that you're not obviously a clinical expert, and that you haven't had sight of medical records or material related to the mental health of some of the detained persons you've been looking at. I want to ask you about your views on the opinions of various other witnesses who've been provided by medical justice about the model of force used against mentally ill detained persons. I've been asked to ask these questions by medical justice. I want to first start with Professor Katona's evidence that's provided to the inquiry. It's at BHM 000030, and it's page 38. Paragraph 77 to 78. Professor Katona, who Dr. Bingham also agrees with, his evidence on this point being at BHM 000033, page 50, paragraph 133, states that the use of physical restraint is likely to be traumatising in itself for detainees with pre-existing clinical vulnerabilities, and risks re-traumatising those with a past history of torture and trauma. And just to be clear, Dr. Bingham is a GP with specialist expertise in mental health in immigration detention, and Professor Katona is a consultant psychiatrist with specialist expertise in refugee and asylum mental health. And the question is, in the selection of cases you've considered, you've raised concerns over several incidents where it appeared force was used inappropriately against vulnerable detainees. We've just been through at least 3 of them. Do you accept that it's possible that, given that you've not seen the underlying clinical material and because of your specific expertise, that there may be other incidents which could be classified as inappropriate restraint of clinically vulnerable detainees?
I think there's every likelihood of that, yes.
We've looked at the training manual a few minutes ago in relation to Article 3. There's a case of A in the UK from 1998, which the training manual sets out. It's at NOM 00001, it's pages 28 to 30. The case is quoted, noting that the physical or mental effects of ill treatment being relevant to whether the treatment was has attained the minimal set level of severity to reach the Article 3 threshold, as well as the state of the health of the victim. The guidance then states, if an officer uses force and the use of force cannot be justified, depending on the severity of the force used, this may amount to a breach of Article 3. The age of the prisoner is relevant when assessing whether or not Article 3 has been infringed, as is the physical and mental effects of the use of force. Do you agree, therefore, that the manual confirms the severity or impact of the use of force is likely to be much higher where it has mental health effects?
Yes, definitely, and that's an area of it's in development at the moment. There's a lot of issues, not only within the immigration centre population, but within the prison population with prisoners with mental health. So that's an area that, as I know, there's substantive work going on at the moment to try and build more sort of knowledge base for staff to understand and relate that to the use of force as well as everyday engagement as well.
We'll come on in a moment to the proposed solution that you suggest in your recommendations and current thinking as well. In your second report, you state that the medical advice elements of the use of force training manual, together with the medical DVD shown, presumably in the training, the medical
Yes,
DVD,
yeah.
Does not include considerations of vulnerabilities relating to mental illness or a history of trauma or torture. Do you think it ought to?
Yes.
And why is that?
Because obviously it's a very sort of specific area, and I think it's probably the one of the areas where staff sometimes can't relate to, having never experienced it. So it's an understanding of what people have gone through, how they experience it, what the long-term effects of it are as well, which I don't think, if you've had no education, you've had no guidance, you wouldn't be able to understand that, and you would be unaware of it as well.
When you say the long-term effects of it, do you mean the long-term effects of the mental health
Of possible
problem
torture, abuse, etc. Yes. Yeah.
I see. In your first report, page 145, paragraph 634, you note that CNR techniques have been medically evaluated as providing a safe system as is reasonably possible. And in the second report, you say that these techniques were medically evaluated by Dr. McConaughey using a risk matrix method, considering age, gender, physical abilities, risk of injury and necessity to use force. So the test criteria used to medically evaluate the appropriateness and safety of CNR techniques employed in a IRC does not then include consideration of mental illness or vulnerabilities such as histories of torture and trauma. Is that right?
Yes, that's right.
And that's still the case now, is it?
Yes, yeah. The manual and the training hasn't been updated since the 2015 version.
And have you seen any evidence during this inquiry that Serco have delivered training or have anything similar to address those problems?
Not to my knowledge, but it's not something I've investigated, no.
I want to ask you now about Dr. Brody Patterson's opinion. He provided his opinions within a witness statement, which is at BHM 000045. That's pages 2 and 3, paragraphs 1 to 9. Dr. Patterson is an experienced practitioner, academic and researcher who's a registered mental health and learning disability nurse. He also taught CNR and pioneered a restraint reduction project in the UK following a report on restraint-related deaths. I'd like to ask you if you've got any comments on some of his conclusions. These are also questions asked by Medical Justice. Firstly, Dr. Patterson finds that the suitability of any restraint model in the IRC setting should be considered against the comparative standards in clinical and mental health context, in which the CNR model is not used and force is only used as a last resort. Would you agree with that?
In part, I think there are, as you've identified, there are a large number of people with mental health issues in the IRC. There are also people without mental health issues. And as we always say, the use of force training and the use of force in general is the last resort. It's when all other methods have failed, and it has to be accepted there are times when force is the only option in extreme circumstances.
Even against mentally unwell detainees?
Yes. Yeah.
And what circumstances would they be, do you think?
If they were attacking someone, so for instance, if they were attacking a member of staff or another person, then I think it's only right that force be used to prevent that risk at that time.
Secondly, the use of high tariff restraints and pain compliance techniques are of particular concern in respect of detainees suffering from mental illness, including those who have experienced trauma, says Dr. Patterson. Do you have any comment to make on this?
Yeah, I think within the training, pain-inducing techniques are not used as a matter of course. They're used infrequently. There are a number of techniques that can be used, and as we've said earlier, pain-inducing techniques are at the extreme end of the curriculum. So there are times when there's no other option available, or the imminent risk requires such a technique to be used.
You said in your second report, page 7, paragraph 2.3, before a planned removal, information should be provided to staff if the detainee is clinically vulnerable or has significant pre-existing injuries. All restraints must only use the force necessary and for the shortest time, but on occasions where the guidance permits, the use of PIT could assist in bringing a swift resolution to an incident that would otherwise become protracted and possibly cause injuries to the detainee or staff. And in addition, a prolonged restraint may have a negative psychological impact on the detainee. Dr. Brody finds that detainees suffering from mental health problems, especially during crisis, may have impaired responses to the coercive use of pain application, leading to the risk of escalating the duration or intensity of the restraints. Do you have any comment to make about that?
My comments were based on conversations I had several years ago with medical practitioners that highlighted the effects of a prolonged restraint, that sometimes that could have more effect on someone, especially someone with mental health issues, and that sometimes using pain-inducing techniques to bring about a swifter resolution would be more advantageous, but not at the detriment of the interaction as well. So it's I think there's a lot of different viewpoints and people with different opinions on these matters. For instance, a lot of people will say using things in a policing world of using a taser against using hands-on techniques, so to speak. So it's balancing it up in that perspective.
But can you see where, in particular, using that technique, a pain-inducing technique, may have a different effect on somebody who, for example, had been tortured, who had experienced exactly pain-inducing techniques, but not in such a controlled way? Can you see how that would cause particular distress to that person?
I can, but I do have to reiterate that the pain-inducing techniques that I mentioned earlier, they're up to 5 seconds. You said for 5 seconds, they're up to 5 seconds, so it could actually be far less. It could be a split second, it could be a second, it could be full 5 seconds. But they're not held on for any longer than that. So it is, as the old term used to be, like a short, sharp burst, and that was it. And then obviously it would progress from there, and then staff would look at other techniques. And quite often we would say to staff, if the pain-inducing technique isn't effective, then you might have to discount that. Don't keep trying it every time, because sometimes it's clearly obvious that it's not going to be effective and not achieve your aims at that time.
Dr. Brody referred to if someone suffers from mental health problems, having an impaired response. What about where someone has perhaps an impaired response to an instruction given by a officer due to their mental illness?
Yeah.
Can you see circumstances where the last resort might need to be put back a bit? So the force must if the force used on somebody who was not mentally unwell would be different to if they were mentally unwell in terms of the timings.
Yeah, if someone's got a known medical condition and staff are aware of that, then I think there's a different strategy to be employed. As you say, it could be taking longer. It could be a different way of putting the points across. So asking questions in a slightly different way so that person is more understanding of what's being asked of them. So I think it's important to understand that there's a wide range of skills, and that it shouldn't be that staff just have a one go-to kind of method of resolving or engaging.
But in terms of timings, that last resort could come at a different point.
Yes. Yeah.
If somebody was mentally unwell.
Yeah, I agree with that. Yes.
Giving someone longer to comply than in other circumstances.
Yes. Yeah.
In your second report, you acknowledge the opinion of Dr. Patterson. There's in your report at page 55, paragraphs 30.2 to 30.3. You acknowledge his opinion concerning the merits of an alternative use of force model used in a mental health context. You state you wholeheartedly agree with a more therapeutic approach to intervention in the IRC, where use of force would be restricted to last resort contingencies and to preserve life or prevent serious harm. Also in your third report, you continue at paragraph 30.4, the ideal model is to incorporate a combination package of both models, one being delivered by trained staff prior to use of force training, and the second by accredited use of force instructors who have a knowledge base in the care methods and who can align them with use of force training. Many of the de-escalation and communication skills will be transferable into use of force instance and scenario-based training, would condense the two as part of the DCO accreditation process overseen by representatives from both groups. Yeah. Also in the same paragraph, you said that there is a complex mix of detainees at Brook House who have mental health problems and other vulnerabilities, as well as ex-prisoners. And you state that specific to ILCs is that those held there could have experienced torture, loss of family members and persecution. What is your view on Dr. Patterson's view that the current prison-based CNR model is inappropriate for use in the IRC setting, as it fails to reflect the complex mix of detainees with a wide range of care needs?
I think that's what my comments were made, that joint approach. My comments also ended with there has to be that contingency for when all other reasonable efforts have tried and failed, or the imminent risk of harm, dictates that force has to be used. But I agree that, as I said in there, there's therapeutic methods that are out there. I've experienced it myself when I've seen the MMPR manual, which is a system used in the youth custody estate, where there's a sort of behaviour management package, and that works alongside the use of force. So having seen that, excuse me, and seen how that operates and the effectiveness of it, it supports what I was saying there, that that joint approach is, in my view, the best method, because there is always that contingency where you do need, dare I say it, the hands-on approach at the end of it.
Dr. Patterson criticises the current model. He says in his witness statement, BH 000045, pages 10 to 11, paragraphs 44 to 47, that the HMPPS CNR model fails to offer a sufficient hierarchy of interventions geared towards primary prevention and de-escalation strategies, which is or should be adapted to the vulnerabilities of a IRC detained cohort. Do you agree that there should be a hierarchy of interventions geared towards prevention and de-escalation? There
is. I think what he's referring to is just the use of force manual. However, within the curriculum for prison officers especially, there is the part on interpersonal skills, de-escalation skills. So that is already taught before the use of force training, so it's already there. The use of force manual can't cover all of the other areas, because that in general is part of everyday custody work. So, you know, it does exist, it's just not written into the use of force manual, and then the use of force manual is then aligned to that, and that's referenced when training takes place. Do you think there should be something within the use of force manual that specifically either references that other training that's taken place on personal safety measures, de-escalation techniques and so on, at the very least? That's what's happening on the version that's being in production now. So that will reference in the prison world things like 5-minute intervention, offender manager and custody training as well. So all of those areas are being linked to the use of force training. Let's go on to that now, in terms of proposed changes. In your report, in your recommendation for force being used as a last resort, you suggested that a bespoke package should be considered for staff working in IRCs to cover behaviour management, and it should be therapeutic based, focusing on preventative strategies as opposed to reactive strategies when a situation has escalated. This is page 148 of your first report. In your second report, at paragraph 24.7, you say there is information coming through now on bespoke strategies for managing those with mental health issues. With an increase in staff within the centre, there is more scope for individual personal officers. Their role will be to document how to engage with the detainee, understanding triggers for behaviour, and tried and tested de-escalation methods. Also in your second report, paragraphs 30.5 to 30.6, you state this at 30.5, that there should be a bespoke package to improve culture and care at Brook House. Good example, MMPR training package, which has a section developed by a behaviour management expert alongside the physical techniques developed by HMPPS. MMPR national trainers and local coordinators deliver the full syllabus, which may not be suitable for IRCs, where dual tutor lead delivery may be more appropriate. And at 30.6, you say HMMPS have introduced a similar version of the model as the model you've just mentioned, training in 5 minutes intervention, which is being rolled out across the estate to supplement use of force and behaviour management. Can you explain a little bit about what training in 5-minute interventions is? It's more about, it covers a whole range of safety aspects. So it can cover things like activation of body cams, about the level of questioning, how you engage with people. So it's all them kind of exploratory sort of ways of resolving a problem, but also being able to identify differences in behaviours beforehand. So when I talk about preventive measures, it's not reacting to someone who's suddenly shown a real change in their behaviour pattern. It's somebody picking up on that much quicker. and that's where the sort of like the offender management scheme coming in, whereby staff have an allocated number of people that they're responsible for, and they have regular engagement with them.
Do you know if that would be applicable to IRCs?
I'm not sure on that one. I couldn't tell you.
Would you recommend it is, given what you've heard today?
I think there's parts of it that could be used. I think it would need to be adapted slightly, because I think there's areas that I think IRCs are so specific that they couldn't just take a generic package, which I think has been a lot of the problems in the past, which is why I referenced the MMPR model.
And what is about the MMPR model do you think would be useful in IRC settings?
If I'm being honest, I think from my observations of MMPR and sort of my involvement with it, is the external behaviour management part of it. So it's somebody who's taken that skill set that they have and incorporating it into what would be a young offender institution environment. That to me is better, and it's a model that seems to work because, as I say, their crossover then with the use of force trainers is that they understand that model more, and that helps them with the delivery of use of force training.
Emma Ginn, in her witness statement at BHM 000041, provides an overview of findings and recommendation of Baroness Loans 2010 review concerning use of force complaints and investigation process. I don't know if you're aware of that review.
No.
Specifically, her recommendation was that the Home Office undertake, quote, a review of the control and restraint techniques and of the guidance used to determine what improvements could be made. Such a review should encompass consideration of control and restraint training and physical techniques used in mental health establishments. Would you accept this recommendation does not appear to have been implemented as or carried out in practice by the Home Office?
Not to my knowledge, no.
You propose a bespoke communication package which has more behaviour management and therapeutic based. Would it still preserve the HMPPS CNR model of physical restraints?
There's some elements, definitely so. I think, again, the other package that was developed for the Home Office for the escorting of detainees encompassed parts of the use of force syllabus, but also areas that were specific to the environment that they operated in, i.e. Transporting people on aircraft and in-country escorts as well.
What about in relation to detainees who are mentally ill? Would that be part of the change to the CNR model of physical restraint, or would this be a part of the other element of the model you're sort of talking about?
I think with the, as I mentioned earlier, the increase in mental health within the prison population, it's definitely something that has to be considered and has to be implemented at some point. How quickly that will take place, I can't comment on at the moment, but it's certainly something that needs to be built in along with the relevant techniques with people suffering from mental illness.
If there is to be a redesign, would you agree that it would be useful to have clinical expertise and input from those who specialise in mental health issues in immigration detention?
Yeah, all of the restraint techniques and the new training manual that's in development has a cross-agency and multi-disciplinary kind of panel working along it. So it's people looking at it from various different factors, and mental health would be one of those that I would advocate for that, yes.
Thank you, Ms. Collier. I think this is an appropriate time to break for our afternoon break, please. It's just gone 10 past, but should we say 3:30?
Thank you. Thank you very much, Ms. Collier.
Chair. Ms Collier, we're now on to the final topic, which is monitoring and oversight, although it is a rather large one. We'll touch on 6 specific issues which you've identified in your 3 reports relating to monitoring and oversight. And they are firstly the lack of presence of management, which we've already touched on, the failure to activate body-worn camera footage and the failure to film. Thirdly, the failure to report inappropriate behaviour. Fourthly, poor report writing skills. Fifthly, the quality of the debriefs. And finally, the lack of governance. And in fact, those are all topics that we've covered to some extent so far. If I can start with the lack of presence of management at use of force incidents, particularly the duty manager. In your first report, and pages 159 to 160 at paragraph 668, you said that the lack of managers, particularly over DCM level, the lack of management of use of force incidents encourages impunity. What did you mean by that?
I think what happens is the DCMs are almost left to their own devices and they're not getting any guidance at the same time. I think what it also means is that a more senior manager can look maybe with a broader vision of what's going on, rather than just focusing on the actual use of force incident. They're thinking about other factors as well. So I think what it does, it gives that greater level of assurance that the whole situation is being managed rather than just focusing on the use of force. That applies more to some of the unplanned incidents that were I witnessed on, or that I saw footage of. A lot of them were incidents that sort of came out of nowhere, and staff responded, and there was no senior manager presence there to help and give guidance on that. And again, it goes back to the earlier point about situations like where detainees access the netting. It's something there that you think a senior manager there could say, right, this is what we're going to do now, and then set up a structure from there.
And what about the absence of a duty manager? Are you including that person as a
That's principally the
senior
person
management?
that I mean, yes, yeah. So in a prison equivalent, it would be the duty governor.
Secondly, I want to ask you about the failure to activate body-worn camera and film relevant aspects of use of force. In your first report, paragraph 669, your conclusions, you refer to numerous examples where there's no body-worn footage available. Please can you explain the importance of the use of body-worn camera footage in relation to use of force incidents?
So during use of force incidents, for me, again, it's a twofold approach. It's as much as it is for the people actually involved in the use of force, it's more for the people that respond or are in the area. Often when you see the footage or you review the footage of someone actually involved, it can appear somewhat chaotic, and also the camera flicks to the position that the person that's recording it is in. So for instance, if they're trying to control an arm, all you're going to see is that arm, you're not seeing the whole vision. And where the real failure and where the omission was at Brook House at the time was that sort of culture where people, when they responded, to automatically activate their body cameras so that they could get a wider picture of what was going on. And that gives far better evidence, and that enhances the review process at that time. And again, for me, a lot of the time it was the DCM grades who, unfortunately, were the ones who were the main culprits.
And what you mean? Do you mean that they were not activating?
Not activating it. There was
body-worn
certainly
camera?
footage where I would see 2, maybe 3 DCMs, and there'd be just one bit of either CCTV camera footage, but nothing from body cams.
You've made a recommendation in this respect, recommendation 5, which is in your first report, pages 150 to 151, paragraphs 647, 649, that there should be a policy or operating procedure produced for body-worn use and activation, alongside use of a handheld device if PSI 04/17 is not adopted. I'd ask, please, Zainab, we bring up that PSI. It's NOM 000002. So this is the PSI that was around at the time
Yes.
of the relevant period, effective 20th of March 2017, just before the relevant period. See that in the middle of the page. And for action by NOMS Immigration Removal Centre, that's ticked. So that I assume means that that's the applicable policy for IRCs. If we turn, please, to page 23, looking at 5.1, so scrolling up, please, to 5.2. This is about spontaneous use of force. The guidance here is that it should be used when force is likely or where force is being applied. Where unexpected, it should be switched on as soon as possible. An explanation should be given in the statement for delay. And scrolling down to 5.7, planned use of force. The member of staff planning this type of physical intervention must prioritise the use of their handheld video cameras where applicable, and not solely rely solely on body-worn camera footage. In terms of practice now, in your experience of prisons, are handheld or body-worn cameras favoured?
For planned, it's still handheld. Body-worn cameras aren't routinely used for planned interventions unless there is an issue with obtaining a handheld device.
So then please could bring that down and put up a new document, which is SER 000170. This is Serco's use of force standard operating procedure, which is issued there 27th of April 2020. So that's, I understand, the current one in force. And if we please go to page 2, we can see 2.0 body-worn video cameras. As all staff and detainee locations are provided with body-worn video cameras as part of standard uniform. In any instance where a member of staff is responding to an incident or finds it necessary to use force of any kind, the body-worn video camera must be activated without exception. Full instructions on the correct withdrawal, use and return of BWVZs are detailed within the Serco Immigration Security Strategy, which is found on the staff intranet homepage. If we turn to pages 8 and 9 of the same document, please. This contains detail about video recordings of the use of force incidents under the heading video recordings, just at the top there, of use of force incidents. It says it's the policy of Gatwick IRCs and PDA that all planned incidents, and then skipping to, and a potential or actual force will be recorded using handheld video recorder. All spontaneous use of force will be recorded on personal issue BWVCs in combination with established CCTV. And then there's mention of recording to including briefing, debrief, negotiations, use of force, and healthcare assessment. Thank you, you can bring that down. There's another document which I won't bring up, but this is the Serco Immigration Security Strategy, which was mentioned within the document we've just seen at 2.4. This is at SER 000054, and it's pages 4 to 11. This repeats the standing operation and procedure, and also states the retention periods. Is this the policy and operating procedure as you envisaged? Is this adequate in your view?
It's certainly an improvement. There's also, obviously, I haven't seen the full policy or procedure. I think the other big part that needs to be in there is about what action is taken against staff who don't activate body-worn cameras. So if you're reviewing footage and you see someone in attendance or somebody who's involved who hasn't activated it, is what the process is for that. And it's not always necessarily going to be, there could be justifiable reasons why they haven't, but there should be a process within that which I would expect to see as part of the overall procedures document.
In your recommendation 8, which is in your first report, page 153, paragraph 652, you've said that body-worn camera footage, handheld and CCTV evidence is to be available during investigations or complaints. Mr. Hewer's witness statement at SER 000451, page 14, paragraph 64, states that material is reviewed and where there are concerns concerning a use of force incident, this is met, those concerns are met, and the Circuit Immigration Security Strategy, which was the SER 000054, page 9, says that the standard retention for body-worn footage is 120 days. Is that sufficient in your view?
I think if that's the automatic retention period, yes. But obviously, any time that any incident of note has taken place, that should be preserved indefinitely.
I want to go through one example with you about the failure to film an incident rather than a failure to switch on the body-worn footage. It's incident 129/17, and it's concerning D52. In your first report, you describe the incident like this. This is at page 88, paragraphs 351, 352. You said a detained person refused to move from an interview room in the visits area. He had made previous threats against staff and was therefore being relocated to Eden Wing. After attempts at persuading him to move, DCM Aldis instructed staff to restrain the detained person in order for the move to Eden Wing. Paragraph 352. During the restraint, a member of staff was bitten and needs medical attention. Once control was gained, handcuffs were applied and restraints were released, and the detained person was relocated to CSU. We know from paragraph 355 of your first report that DCO Marshall applies a thumb lock as a pain-inducing technique, and you find, and I quote, "No footage to test how long the pit were applied. I am unable to make any further opinion." And this relates, I should say, to whether no more force was used than necessary. Yeah. You comment on the lack of body-worn footage at paragraph 386 of your first report, and you say, "All efforts appear to have been made for a peaceful resolution. Some satisfy the decision to use force with the last option available." And then at paragraph 67, you say you find that it was necessary and proportionate to the threat. However, in your third report, having viewed some of the footage, you say this at paragraphs 20 to 23, 20 to 30, which I'll summarise. Due to the new body-worn footage being available, your opinion has changed, and that the new footage clearly shows that at the point force was initiated, which was around 7 minutes 3, it was not the last resort and use of force was not necessary. In terms of your conclusion on that, you say in your third report, page 7, paragraph 24, "When force was initiated, it was not when all reasonable efforts had been made, and there was no reason for force at that stage. D52 was agitated, but at no time did he offer a threat towards the staff, or did he indicate he would not move, provided they reached an agreement he could go and collect his belongings. More effort should have been made for a resolution that, if necessary, allow D52 time to consider the instructions. Due to the time of day, there was no resolution strategy. At no time did D52 offer any violence to staff, or was there any sign of staff being at risk of harm. The period of discussion is approximately 6 minutes and 30 seconds. Due to the circumstances, I would have expected a longer period to try to find a mutually amicable solution to the issues raised by D52. At paragraph 26, you raise concerns about the operation of the camera, and that's what I want to focus on, although, of course, what we've seen there about the last resort is something that's fed in and we've spoken about throughout your evidence today.
Yes, it was another clear example of inadequate engagement. There was, on the face of it, a very simple solution to this whole incident, which was to escort D52 to his room to collect his belongings, or at least stay there while staff assisted him to collect his belongings. That would have, on the face of it, would have been a simple solution that was mutually agreed by both parties, which would have avoided force being used.
And does it concern you that your opinion had to change dramatically from your first report to your third report due to the existence now of footage?
The footage, and I think what enhanced that was actually that D52 was actually sat down at the time, So he was sat down at a table when the staff used force on him. So to use the risk of harm at that stage is very, very difficult to justify. Well, impossible to justify in my conclusion was the fact he was offering no threat to anyone. He was just angry that he couldn't go and collect his possessions to take with him on transfer.
And does it concern you that this only came out because you were able to view the footage?
Yes, I wouldn't have been able to make that, come to that conclusion without the footage, as my conclusion before has now been proved wrong because I've now got additional evidence which proves otherwise.
Thank you. Please could we play in closed session UOF 129.17 BWC.MOV? Go to closed session now, thank you. Thank you. Mr. Collier, we see there that the camera is uncovered for the 7 minutes or so of conversation. And then as soon as the restraint starts, it's covered by a hand, and then we can't see anything. And when the hand is uncovered, he's on the floor and under control once it's uncovered. Do you have any view on why the camera might have been covered?
At first, when I viewed this footage, in fact, I viewed it several times. At first, I considered that maybe the camera operator was somebody who got involved in the restraint. But when you see the footage, when it goes back onto the D52 while he's being restrained, you can see that the person that was in operation the camera wasn't part of the restraint. So that eliminated that theory, if you like. The only thing I can think of is that someone's deliberately covered the camera. That's the only conclusion I can draw at that stage.
And does that concern you?
Massively, yes. Yes, it's well. It doesn't. It goes against everything that the use of body-worn video camera stands for, to gather evidence, to give a factual sight of what's actually happening, the events as they are happening. So it's almost as though it's obstructing that process.
And just to confirm, this was evidence that was disclosed latterly
Yes.
by G4S in the latest tranche of evidence.
Yes, it was. Yes.
I want to ask you about the since we've seen that footage, because there are many facets to each of the footage that we've seen in each of the incidents, about a pain-inducing technique. You said in your first report that you couldn't comment on the pain-inducing technique due to the lack of body-worn footage. We hear there, I think, from 7 minutes 10 to 7 minutes 50, so about approximately 40 seconds, the detained person screaming. Obviously, we don't know if this was when the pain-inducing technique was being applied, whether it was being applied for the whole time. Are you able to comment, having seen the footage now, whether the pain-inducing technique was applied correctly?
No, I can't, because there's no footage available to see.
I want to move on now to the third topic within monitoring and oversight, and that's failure to report inappropriate behaviour. In your first report, pages 159 to 160, paragraph 668 and 670 in your conclusions, you say that you are concerned that it's only through covert You're concerned only through covert camera footage that action against staff has resulted. Numerous examples of unprofessional behaviour which did not go reported and in some instances seem to have been encouraged. Staff who fail to report wrongdoing or inappropriate behaviour must also be challenged must also be challenged to ensure that detainees are treated with dignity and respect. You've made a recommendation in this respect, recommendation 9, excuse me, which is in your first report, pages 153 to 154, paragraphs 653, 654, and you've suggested that a way of combating this staff wrongdoing and not reporting of wrongdoing is to provide posters, staff leaflets, staff yearly performance reviews and so on. Do you mean in terms of a whistleblowing type of technique, or are you talking about other...
Just
other
reporting
aspects?
any wrongdoing. I think it's every person working in a custodial environment's responsibility to report any wrongdoing. I think it's something that needs to be embedded from the very start of someone's employment. So it's through the initial training course, but it's also something that should be passed on regularly through staff performance meetings. It should be re-emphasised to staff through that. But again, putting the posters, putting the video loops, whatever, about wrongdoing across the centre, so everybody's aware of it and everyone is conversant with it. But most importantly, everyone's got faith with it. That they've got faith that, one, they can remain anonymous, they'll be protected, they won't be victimised. I think that is as important, because unless you've got that, then you've got no chance, in my view, of creating that culture where people will report wrongdoing without fear of retribution.
We know from the evidence that we've heard in this inquiry that there were posters that were up around Brook House encouraging whistleblowing, but that they had snitch and grass scrawled over them. We know that that wasn't sufficient to stop abuse taking place at Brook House. What do you think to the suggestion, as Professor Bosworth has suggested, that more of a cultural change is necessary? It's not just about posters on walls, encouragement of staff to explain wrongdoing.
No, and I think that goes back to the review of certainly of use of force incidents, but it's got to extend further than that. It's got to be built into everyday activities, everyday working, so that people, as I say, everyone has to. I don't even want to use the term buy into it, because it should be just what people default to anyway. It should be not the normal process. I'm concerned about things like posters being sort of vandalised, for want of a better word. There's extensive CCTV around the centre, so once that had been done, I would question why somebody didn't pick that up and look at the CCTV and see and find the culprits, because I think there's, that again is unacceptable, isn't it? You can't expect professional people to be acting in such a way.
I want to come on to the fourth subtopic of poor report writing skills. That's something you mentioned at the beginning of your evidence. In your first report, page 152, paragraph 651, you said the overall standard of post-incident statements is poor in most cases due to a lack of detail of the events prior to, during and after the use of force was applied. Essentially, that's the whole incident, isn't it?
Yes, a lot of people tend to sort of just report on once they arrive, so it's a little bit of background information. So it could be, for example, if someone's had a prior engagement that day with the detainee, to put that in there, the content of that, because that then kind of is a bit of background setting for the incident that took place.
A good example, perhaps, of the poor report writing skills, and one you've identified in your third report, is that of 110/17. You said at paragraph 84 of your third report, several of the incident reports I read do not accurately reflect the additional footage now available. And you use, for instance, 110/17, DCO Pasquale indicated difficulty opening a cell door, but the footage indicates otherwise. Also, why DCO Pasquale entered the room without checking first or summoning others. This is a management failing and does not provide reassurances that incidents involving force are being correctly recorded, which in turn brings into question the legality for using force. What was it that particularly concerned you about Mr. Pasquale's failure to reflect what had actually happened in his report writing?
If I go through the whole incident, first of all, there's, as I said in the report, you could see that there was no difficulty opening the door. If he had have encountered difficulty opening the door, my expectation was that he wouldn't have opened the door. He would have secured the door and then summoned assistance. The fact that he's gone into a room and used force on someone with nobody else in attendance raises concerns. If he was alerted to that room because of either the noise or activity within there, I wouldn't expect someone to go in on their own, and certainly not go in without checking first, because that's kind of ingrained in every custodial officer's role, is to look inside the room first before ever entering.
Excuse me. You said in your third report, paragraph 84, that within recommendation 7 of my first report, I highlight the necessity for use of force reports to be scrutinised by managers. Several of the initial reports I read do not accurately reflect the footage available. Is there any other comment that you'd like to make in terms of how important it is for the report writing to be accurate?
I think the only way staff can be advised or you get the improvement is for reports to be scrutinised by managers, and then the staff challenged if they fail to record all the events, or to record their actions, or to record any interaction that took place, or if there's any falsifying or diversion between what's seen on footage and what's recorded. Now, there may be genuine reasons. Sometimes people can't accurately reflect everything that went on, but that should be found out through a process of scrutiny, rather than what's happened in this instance. It's only through this inquiry that we've actually highlighted that issue.
And this again, I assume, highlights the importance of the body-worn camera footage as well.
Yeah.
You've made a recommendation in that respect, recommendation 7, which is at page 152 of your first report, paragraph 651, where you've said that line managers assisted by the use of force instructor should carry out random quality assurance checks on completed use of force statements. Additional training be provided where necessary, and to enhance understanding and issue all staff a pocket guide on how to effectively structure a report, including essential contents before, during and after the incident, and any personal emotions experienced during the incident. In terms of current practice, we know from Mr. Hewer's witness statement that there is a reference to report writing, and he says that staff are aware that they have the right to add to their reports rather than amend them. However, neither the security strategy or the operating procedure mentions this. Of course, we can ask him when he gives evidence. Do you agree with Mr. Hewer that staff should add and not amend?
Yes, that's part of report writing, that if any other information comes to light or someone can recollect anything that has happened that they didn't initially. One of the issues that I do have, and it became apparent when I visited Brook House recently, was the fact that I was unaware that the timescale for reporting was 24 hours, which is different to the prison services model, which is 72 hours. And I think that carries some weight behind why the report standard is relatively poor, which I have to be honest with, because I don't think staff are given sufficient time. If you think if someone's finished a late shift and then coming in the next day trying to get their report in, then it's very difficult for them to complete it to the level and the standard that we require.
So would you recommend the time limit to be 72 hours as opposed to 24 hours?
Personally, I'd definitely go for 72 hours to remain consistent, but if we were sort of bargaining over it, I'd settle for 48 hours, but yeah, 72 hours would be ideal.
And why the later time rather than the 24 hours? Because there's just simply not enough time in order to provide enough detail.
And I think as well, the longer people get, the more they can reflect on and more comes to mind. So I think it allows that period to remember things better rather than immediately post-incident, where sometimes the emotions are still running very high at that stage and their thought process isn't maybe as accurate as it could be.
I want to move on to the penultimate topic, the fifth topic, quality of debrief, and to use a specific example of incident 137. This is an incident with D390 and D1851. In your third report, paragraphs 14 to 17, page 5, this is another one where additional footage has been looked at. So additional footage covers a very quick debrief, which is essentially asking if he had any injuries. All confirmed that they didn't. He did not address whether any wider issues or concerns from staff or feedback from DCM on performance, whether they were good or bad. The emphasis needs to be for a bespoke package for a DCM group, which is your recommendation 1, on managing incidents, including how to conduct a debrief, what it is set out to achieve, and how to take any learning from it. An effective debrief not only covers welfare issues, but also training needs and learning. Is there anything else that a debrief should cover apart from those topics?
Well, it should identify good practice, should always identify good efforts from staff, and use that as examples for both in training and also rewarding staff. But I think sometimes we've got to be very sort of critical as well, self-critical, about whether the performance of either the DCM. There were times where the actions of the DCM and the management of incidents from the DCM was poor. We've already highlighted that. And I think, again, we go back to that culture that needs to be built in, that if staff feel that, feel they can say that during a debrief, again, without any kind of comeback on that. So it's more about it being a learning process, and rather than just, in most times, and I think I use the phrase, it was again that, has anyone got any injuries, and that was about the extent of it, which is clearly not what the debrief is all about.
Did you see on any of the debriefs that you watched for this inquiry there at any points there to be any recommendations given, any suggestions for improvement, additional training needs, and so on?
I didn't see it on any of the debriefs. I also didn't see it on any of the post-incident reviews by Steve Webb.
And do you think it's possible that out of the 109 incidents which occurred in Brook House, that there weren't any training needs, or
there were many
else?
in the 43 incidents I reviewed, and as I said earlier, it didn't need someone even of an expert eye to identify some areas that improvement was needed.
I want to move then to the final subtopic, which is lack of good governance. I want to use an example of D191, which is on the 24th of April of 2017. In your first report, paragraph 179, page 47, you found that there were several failings in managing the incident, specifically by not summoning assistance, having healthcare in attendance, activating body-worn footage, the lack of support when moving on the stairs, lack of senior managers, and you say that whilst not altering my opinion on the use of force, it failed to follow the procedures set out in PSO 1600 for an unplanned incident. This was an incident which Dave Webb was one of the DCOs involved, and then Dave Webb also was the one to review it. You've said that's a problem in your report at 180. Dave Webb cannot review incidents he was involved in. Why is that?
That lacks any credibility. It sort of puts the whole process under scrutiny for being kind of, someone who's involved just shouldn't be involved in that review process. It should be independent. It should be somebody who's got impartiality. And if you're involved yourself, it's almost as though you're reviewing your own homework, so to speak, isn't it? It's just not acceptable.
And there's a conflict of interest.
Massively, yes.
Please can we have a look at the review for that incident? It's CJS 000902 and it's page 3. We can see there the date, which is the 17th of July. The incident having taken place, just to remind you, is the 24th of April. Although the incident of the date, there's no box for the date of the incident. And if we look down the page, we can see at the bottom the outcome of the review. Further investigation required, no. Letters of commendation required, no. Lessons learned and further training, no. No further action, no. And then that's signed Steve Webb, DCM, CNR instructor. You've mentioned various criticisms of that incident, and that was having looked at the body-worn footage. How confident can you be that that Steve Webb had viewed that footage?
Well, if he had done and still came to that conclusion, then again that's a massive failing, and it would question his ability to effectively review footage and understand the use of force that he is an instructor in.
And should he have identified their points for learning in perhaps the comments box from the ones that you've identified?
Yes, along with several others as well, a vast majority of the other ones as well.
Thank you, take that down. In that pack of 30 incidents, the CJS 000902, pages 1 to 30, they're one review each page. There are no comments or lessons learned in the 30 incidents reviewed, which were reviewed over a 2-day period. Do you agree that there's likely to have actually been no learning from any of them?
But there must have been some learning. You can always take learning out of any incident, so to say out of that amount of incidents there was no learning from any of them is no, I can't agree with that.
You've described in your first report, paragraph 27, that the instant review system in place at the time amounted to no more than a tick box exercise. What did you mean by that?
I think what we've just seen on the screen is a classic example. The boxes are ticked and nothing else added, so it's as though they just go through it, make sure there's nothing, they tick all the boxes as in all the use of force statements are there, the F213's been completed, no injuries to staff, no injuries to detainee, and that seems to be the amount of the review.
In live evidence, Mr. Webb agreed that it was a tick box exercise, and that no meeting took place, that it was just him on his own doing a paper-based exercise on his days off.
Okay.
What do you think about the delay in reviewing these incidents? So we know that, for example, the D191 incident took place on the 24th of April. Yes, it wasn't reviewed almost 3 months later, on the 17th of July 2017. Do you see any problems with this delay?
The major problem is if there's been any inappropriate action by staff, it's gone unaddressed. So it's something that needs to be picked up early. The other thing is if there is a failing by a member of staff through incompetence in technique or using techniques that put the detainees in danger through incompetence, that's not being addressed. The risk is if it hasn't been picked up early, there's a chance of it being repeated with possibly more consequences.
And what also about the fact that perhaps memories would fade during that time if indeed it needed to be investigated on a higher level?
Well, if it did, the staff involved will only be able to go back on their use of force statement, which I'd already identified were in general not to a very good standard.
So those levels of scrutiny which were failing were compounded?
Yes, yeah.
This takes us to your recommendation 3, which is in your first report, pages 148 to 149, and it's paragraphs 642 to 644. You say that there should be a multi-agency use of force committee as directed in PSI 30-2015, chaired by the director, and it should meet quarterly and should include a detained person representative. In addition, as soon as possible after every incident, a review should be conducted by a suitable manager to ensure emergency action is taken. All documentation should be collated, including footage, and then safely stored. We're told by Mr. Hewer that use of force committees have now been established. It's chaired by the Assistant Director of Security and attended by senior management, use of force coordinator and other key stakeholders, including the IMB. However, it's not clear on the inquiry's analysis whether or not detainee representatives should be included. Why was it that you felt that a detainee representative should be included?
I think it provides transparency. I think it allows the detainee group to have knowledge of how incidents are reviewed, that if force is used against them, that it is properly scrutinised, that if there is any inappropriate actions or anything that's come out of it, then it's being addressed at the correct level.
Mr. Hewer says that the committee meets monthly and reviews trends and agrees actions to review use of force further. This is in the Standing Operating Procedure, SER 0001, 70 pages 22 to 23. And they say they do this by reviewing one use of force from the previous month. He also says that a senior manager now oversees all planned use of force debriefs, although there's no explanation as to why it's not extended to unplanned. He says that every use of force is reviewed within 24 hours by Assistant Director of Security and use of force coordinator. And this includes use of force reports, footage, risk assessments, details of injury sustained, and that authority representatives and IMB members are also invited to attend. How does that information affect what you would recommend?
I think it's a step forward. I question if you're identifying specifically who carries out that review in 24 hours, because they're not always going to be available within 24 hours of each incident. I think reviewing one incident from a month is insufficient for a panel. I think it should be more than that. And also there should always be the caveat that if any incident has raised any serious concerns, i.e. it's resulted in an injury to a member of staff, to one of the detained person, or there's been major issues arising from that incident, there should be like that emergency kind of gathering afterwards to review them incidents.
Overall, taking account of what we have just looked at, just in the monitoring and oversight section of your evidence, we've seen the lack of presence of management, the failure to activate body-worn camera and the failure to film, possibly even deliberately, failure to report inappropriate behaviour, poor report writing skills, lack of quality of a debrief and the lack of governance. Is it fair to say that the quality of monitoring and governance of use of force at Brook House in this relevant period was poor?
In my opinion, it's very poor, and it's something that I'm sort of disappointed with from the instructor level, that it wasn't better managed. And yeah, as the operator, knowing the operator, I'm surprised that they have allowed that to go on, to be honest.
And could it have let bad practices flourish and go unchecked?
Yes, anything that doesn't get proper scrutiny and governance has that capability for, as I say, trends, behaviours, and even opinions of some staff. We've already identified that the general census of opinion was that all planned incidents have to be in PPE, whereas actually a review committee would have picked that up. So there's lots of areas that it's led to the position that we're in now.
Thank you, Mr. Collier. Those are all the questions I have for you. Chair, do you have any questions?
Thank you, Ms Townsend. And thank you very much, Mr Collier. I do have a couple of questions for you. And do please just answer them to the best of your ability. So if you feel that they're outside your area of expertise, then please do just say. We've heard some evidence from former members of staff about their perceptions of being used repeatedly for use of force, and the negative impact that had on them. Is there anything you can tell me about that as an issue based on your experience? Is the good practice?
I think one of the footage we saw earlier, where there was a member of staff that was struggling at that stage. I think if you have a core group that you go-to group, so to speak, if they're not on duty or the situation arises, because obviously the centre's in operation 24 hours a day, use of force could take place at any time, day or night, you're not always going to have that capability there. So for me, it's definitely something that needs to be addressed, that if you have then small groups, because what you can also do is get that sort of click type thing within the group, that that sometimes they operate in their own way, whereas if you've got more sort of variance in staff being involved, then you will get a more mixed group there that will have different attitudes and will stop some of them attitudes and behaviours sort of fostering between the group.
Thank you, that's very helpful. We also heard some evidence from a former member of staff about the use of what he termed a mirroring technique, whereby using a detainee in this instance's language back at them, and he characterised that as something that's in the training, a legitimate technique. We're talking in this instance about the use of swearing. Have you got any observations about is the training on that? Do you have a view on the appropriateness of swearing during...
The way you've just described it is something I've not heard before. Okay. So I'm unaware of what it actually meant. Obviously you described it for me, but it's not something I'd be considering. And it's certainly not something I would say is applicable or certainly relevant, because when you're engaging with someone, what you're trying to do is you're trying to calm someone down, certainly in a use of force situation. So anything that's going to inflame the situation by inflammatory language, references, terminology, can all have a detrimental effect on your management of that, and also the perception of the person that you're dealing with about you. So what you're trying to do is personify that characteristic of somebody who's in control of the situation, that's willing to engage, that doesn't resort to swearing, bad language. So I think, that technique is certainly nothing that's in training. It's not something I've been aware of.
Okay, thank you very much. And then my final question. When you've been reviewing these incidents, and also more broadly in your experience, I'd be interested to kind of hear your views and perspectives. Can you tell me anything about attempts to de-escalate and communicate with people in a language other than English? Did you encounter any interpreters? Did you encounter anything that would where a language is being translated?
Not in any of the incidents I reviewed. Okay. My personal experience from a prison environment, if we've got someone whose English isn't their first language, efforts can be made to bring in somebody, certainly for a planned intervention if it's there. That's not always possible, but it's certainly something that wasn't evident there, which when you base it on the fact of it is a immigration removal centre, the nationality count is quite high, I would imagine, of different nationalities in the centre, is something that again should have been a consideration. But as I say, it's not always possible, but I think there should have been provisions for that to be provided.
That's very helpful. Thank you very
Okay.
much. It's been
Thank
a
you.
long day, and I've been very grateful for your evidence.
All right.
Thank you, Mr. Collier. Thank you, Ms. Townsend.
Thank you, Chair. Tomorrow morning we'll hear from Gordon Brooklington.
Thank you. 10 o'clock.
Yes, thank you.
Thank you.